Thank you very much. Thank you also, Dermot, for inviting me. It sounds as if it's been a very good week here. What I have done is, rather than do slides for this, is do a paper which I hope, copies of which I hope have found their way to at least most of you. You will be relieved to hear I don't intend to read it all out. I'll try and pick on some of the more interesting current points, and it is there for you to read at your leisure over the weekend if you're sad enough to have nothing better to do. As Jack says, it is probably what I'm going to be talking about is remedies. So this is the point at which it's all gone wrong, despite everyone's best efforts. Either something's gone wrong with the procurement, or some impertinent bidder claims that something has gone wrong with it. I think it is true, as Jack says, that there has not been quite such an upsurge in procurement litigation as some people thought there would be when the amended remedies regime came in at the back end of 2009. And certainly there has not been at the moment a huge increase in procurement cases actually reaching court, going to trial, leading to a concluded judgment. But there certainly is at least some upturn in the number of proceedings that are being started against contracting authorities, and definitely an upturn in the number of threatened proceedings. There is no doubt that contractors are reaching for their lawyers more readily at the conclusion of an unsuccessful procurement. It remains the case, I think, that the vast majority of procurement challenges are brought or threatened by people who have taken part in a procurement and have been disappointed with the result of it. There are many, many situations. I mean, most of the advisory work that crosses my desk is to do with authorities asking themselves whether they need to run a procurement at all. Is this development agreement a works contract? Will this variation of an existing agreement amount to a new contract that has to be procured? Is this proposed framework agreement too broadly expressed to be lawful? And often there are things out there that you think could very readily be challenged, but that is not the practical reality of what people actually... People do not go out looking to challenge these things, partly, I think, because there is not the sufficient commercial return in doing so. I mean, suppose you challenge an authority that's not running a procurement. What's the best you get? You make them run a procurement. But unless you're very confident that in the event of an open procurement you're going to come out the winner of it, you're having to invest a lot of money in litigation to a wholly speculative end. There is also still the taboo factor. It varies in England and Wales, I think, from sector to sector. In some sectors, including construction, elements of repairs and maintenance, the waste sector, there is now quite a prevalent tendency for people to challenge. In other sectors, and I think big ICT projects is probably an example, the prevailing attitude still seems to me to be relatively one of people not wanting to rock the boat, to be concerned about whether they will have their card marked with authorities in the future if they challenge. But these taboos can change and disappear, and what we see in Northern Ireland, for example, is people often ask, why is procurement so much more litigious in Northern Ireland? There are a variety of reasons. One, which has already been mentioned, is that the public sector is so much more dominant there. People can't afford to lose public sector contracts, may have nothing to lose by challenging. There's also just the element of breaking the taboo. In a sense, it's now more surprising in Northern Ireland if an unsuccessful bidder doesn't challenge the process than if they do. The judiciary there have also been more interventionist than in England and Wales. In fact, Mr. Justice McCluskey, whose words of wisdom about which planet bidders come from we've already seen this morning, is a particularly interventionist judge who scrutinises very rigorously the efforts of contracting authorities. English judges really not to the same extent at all. I think the true happy medium lies somewhere in between the two approaches. So that's just a few general thoughts on the current picture in procurement litigation. What I'm going to talk about now is the issue of remedies and what can people get out of a procurement challenge, and by what procedure can they challenge, which ties with the question of who can actually make a challenge. And I'm going to talk about it under four heads. First of all, claims under the public contracts regulations. Secondly, claims by way of judicial review. Thirdly, claims based on the idea of an implied contract between client and bidder in connection with the tender process. And fourthly and finally, one that it's important not to lose sight of, particularly big projects, the possibility of a complaint to an investigation by the European Commission. So, remedies under the public contracts regs, first of all, and I'm going to talk about that under two sections. First of all, remedies at the interim stage, and secondly, remedies at trial. There's been a lot of focus on the question of interim remedies. I think to the unjustified relegation of the question of what remedies people may actually get if they take a claim successfully to trial, which is extremely important and so far not very much developed. Interim stage, first of all, though, where are we? Well, as you know, the position now is that if someone issues a claim under the public contracts regulations and brings that to the attention of the contracting authority, the process is automatically suspended. It then becomes unlawful for the authority to conclude the contract, and if they go ahead and do so, then that's one of the grounds on which it could subsequently be declared ineffective. So interim suspension is in place, and it is then up to the authority, if it chooses to do so, to make an application to the court to have the suspension lifted. And before the new remedies came in, a lot of talk about was there now in effect going to be some sort of presumption that the position should be frozen until trial. That is not the way in which it is worked out in practice. The courts have reaffirmed strongly that they are continuing to apply exactly the same approach that applied in the old days when it was up to the claimants to go off and ask for an interim injunction to hold the position. It's just that now it's the authority that has to make an application to the court. And the courts apply what are called the American cyanamide principles. That means the claimant has first of all got to show there's a serious issue to be tried, that its arguments about why the procurement is unlawful raise a serious issue. Secondly, if the claimant gets over that hurdle, the court asks itself, would damages be an adequate remedy at trial? And the philosophy is that if you could be sufficiently compensated by an award of damages, if you win, you don't need the position frozen. And of course, the background to all this, as you know, is that once the contract has been concluded, the only remedy then, if the claim does succeed at trial, is one of damages. It's too late to set the contract aside once it's actually been entered into. So, serious issue, would damages be an adequate remedy? And then, if damages wouldn't be an adequate remedy, the court carries out a sort of overall balancing exercise, looking at what's called the balance of convenience, what's the bigger injustice, letting the authority go ahead and conclude the contract and then finding out at trial it was unlawful, or is the bigger injustice holding it all up and then finding out at trial that it was all a lawful procurement after all? And in weighing up that balance, the court will look at things like the strength of the claim, whether the claimant's offering a cross-undertaking in damages, a promise to compensate the authority if its claim fails in the end and it's held things up, the interests of third parties, e.g. the successful bidder, and also the wider public interest. Is there a strong public interest for some reason in getting this contract concluded sooner rather than later? So those are the factors that get looked at. As a matter of fact, the majority of the contested cases in England and Wales have led to the suspension being lifted. Whereas in Northern Ireland, Mr Justice McCluskey now doing almost all these cases, I think he has refused to lift the suspension in 7 out of the 8 cases that have come before him, or something of that nature. That partly reflects his views, but also one shouldn't lose sight of the fact that all these interim relief cases are very much driven by the court's perception of the strength of the underlying case, in my opinion. If they think there's a good case there, there's a strong temptation to try and hold the ring until trial, especially if you can have a trial quickly. Where if it's a weak case, they don't really want to hold things up, even if it passes the serious issue test. And there's a sort of tip of the iceberg effect. One probably ought to keep in mind there are probably lots of cases out there in England where the authority hasn't actually applied to lift the suspension because it is a stronger challenge than some of the ones we actually see going to court. I won't take up too much more time on interim remedies, but in the paper I've set out the reasons why I think the current approach of the courts is questionable on one particular issue, which is that of the adequacy of damages. I question why, just because damages are adequate, that should be a complete bar to interim relief as opposed to one factor to be considered. I think the thrust of the European jurisprudence, going back to the Alcatel case, is really that if something's gone wrong, there should be an opportunity to put it right and not just an award of compensation afterwards. I think the courts are also too willing to say that damages are an adequate remedy in cases where it will be very difficult at trial to work out just what the damages actually are. Let me move on, though, to remedies at trial, which is towards the bottom of page 5 of the paper, if anyone's following it. And there hasn't been much to draw on as yet. It's very important to think about this, though, not least from a potential claimant's point of view. What are you actually going to get if you win the case? And there are a number of these cases where victories have turned out to be rather Pyrrhic. A particularly classic example is the pair of cases that I think Anna-Marie mentioned earlier on, 2 big Northern Ireland challenges to awards of frameworks, the Henry Brothers case and the McLaughlin and Harvey case. Both of them, the award of a framework was successfully challenged. Henry Brothers, who brought the Henry Brothers case, had been one of the successful bidders for the framework in the McLaughlin and Harvey case. McLaughlin and Harvey, who brought the McLaughlin and Harvey case, had been one of the successful bidders for the framework agreement in the Henry Brothers case. The net effect of their having spent untold dosh on lawyers, indeed the same set of lawyers, at least at QC level in each case, was they simply stymied each other completely. And instead of having got some work under one framework at least, both frameworks simply collapsed altogether. So, be careful what you wish for is a good maxim for people who are contemplating procurement litigation. This is not always so. I mean, I did the first case I did in Northern Ireland, in fact the first procurement case that went to trial there, was a waste contract, It was at the time, possibly still is, the biggest local authority contract that ever been awarded in Northern Ireland. And my client, by dint of winning at trial and getting the tenders reconsidered, got that contract, which it would not otherwise have done. And as far as I know, they're still living happily ever after on the proceeds. So that's great. But another case, which I mentioned in the paper, Resource NI and the Northern Ireland Courts and Tribunals Service, we had a stonking victory at trial last autumn, but the bids have just been remarked, and they've managed to decide my client was further off the winning bid than it was in the first place. We may have our deep, dark suspicions about what has gone on behind the scenes, but proving it is another story. And so, my clients can console themselves with the fact that as a result of the litigation, they've carried on performing the contract as the incumbent contractor and have raked in £1 million more than they would otherwise have done. So they're not too heartbroken by it all. But again, one needs to think about what is ultimately going to come out of it. A couple of cases in particular to mention. One is the Mirs and Leeds City Council case, which again was mentioned in an earlier talk. About the problem there was failure to disclose criteria properly. The interesting thing about it from a remedies point of view is that the court held that even when you get to trial and the claimant has succeeded, the choice of remedy is still discretionary. That was a case where the contract had not been concluded. I forget whether there'd been a suspension or an injunction, or whether the authority had just not concluded it pending the trial. But in principle, because there was no concluded contract, the court didn't have to award just damages. It could have set the whole thing aside, but it refused to do so as a matter of discretion. It said there was still a balance to be struck between the public interest in getting on with the contract and the private rights of the contractor. And it limited the remedy to one of damages. The other case I've mentioned there in the middle of page 6 is the Resource NI case to which I've just referred. And that was interesting in terms of the marking decision was set aside there because of what had gone wrong with the marking. But what my clients, the plaintiff, wanted to do was to set aside just the narrow bit where the other lot had been excessively generously marked to the extent of manifest error. But the judge wouldn't do that. In fact, what we actually asked for is, look, we said, you've gone wrong, they've gone wrong in this bit. We were neck and neck. Clearly, if they'd marked that right, we would have come out on top, and you should declare that we should have been awarded the contract. But the judge was very reluctant to do that. He said that would be a very rare thing to do, and the court would have to be absolutely certain, in effect, that that would have been the outcome. And he also said, I think the award decision is a sort of indivisible whole, and I'm not prepared to require or permit the authority just to remark one little bit. He said the whole thing had to be remarked, which is how we got shafted, to use the technical legal term, on the resumed process. What happens if you do actually have to calculate damages? Not much case law to go on at the moment. Everyone knows it's done on a loss of a chance basis. You work out what's the percentage chance that the claimant would have been awarded the contract if things had been done properly. What profit would they have made under the contract if they had got it? And you multiply one by t'other. Easy to say, in a lot of cases rather harder to apply that. Maybe quite easy, and if it's a discrete marking complaint, you had no business giving me 2 out of 5 instead of 5 out of 5 under this head. It was a manifest error. You can see what the consequence would be if it had done properly. So too maybe if you're complaining that someone has been improperly disqualified or hasn't been disqualified when they should have been. You can then see what mark they would otherwise have got. But if you're dealing with something like there wasn't proper disclosure of the criteria, well, suppose the criteria had been fully disclosed to all the bidders would probably have put in slightly different tenders. How do you then work out what would have happened? How do you set a percentage on that lost chance? That's really very difficult. And I think one of the questions that so far remains slightly unanswered is if you don't really know, if it's all speculation, should the court have its best guess, which might give the claimant quite a decent damages claim, or should it just say it's too speculative, they haven't proved that they've lost any particular chance at all, so they get no or only nominal damages? And I think that is going to be an absolutely critical issue that the courts are going to have to confront more directly going forward. Let me just, I've already mentioned the question of being careful what you wish for. Let me just expand on that a bit. This is the bit that starts at the foot of page 7 of the paper. When proceedings start and entry into the contract gets automatically suspended, there is a knee-jerk reaction on both sides, typically in the litigation. The authority says, well, let us at them, we want to lift this suspension and get on with the contract. And the contractor says, I want to fight for my suspension so that I have a chance of actually winning this contract, setting the decision aside, and not just being limited to damages which may be difficult to quantify. But think about it. Think about it first of all from the authority's perspective. Suppose you get the automatic suspension lifted and you go and sign up the contract, great. But that doesn't stop the claimant going ahead to trial if they choose to do so, and suppose they then win. Not so great for you as an authority, because potentially you fetch up paying twice. You pay once to the contractor you've actually signed up with to perform the service or do the works or whatever it is, and then you pay a second time to the claimant by way of its damages for its lost chance. And that's something that authorities need to be very careful about, particularly in cases where the damages could be high. And that might either be those cases where it's going to be easy to quantify the chance. Suppose it's a disqualification case. I've got a case on at the moment. The claimant, my authority disqualified the claimant on the basis it was an abnormally low tender. And they say we weren't entitled to do that. If we weren't entitled to do it, it's clear they would have won the bid. That means if we lose at trial, if we're talking about a damages remedy, it's going to be a 100% case, give or take, which is why we haven't concluded the contract. We're going to wait for the wait for the trial, even though we think we're going to win. We're not sufficiently confident of that. The other kind of case where a damages award could be high is where the percentage you can demonstrate may not be very great, but it's a stonking great contract worth squillions of pounds. Then, even if you can only show a 10 or 20% chance you would have got it, the bill is still potentially high, and authorities need to think about that. Equally, whilst it's perfectly true that a claimant will normally say what we really want here is the contract, we want the work. Look at what happened in the resource case. We thought we could get that contract by the process, but in the end, all we got was a remark in which we lost. Sometimes all you can get if you win and set things aside will be a rerun of the tender process. Who knows what's going to come out of that? May it not, from a contractor's point of view, be rather more attractive to establish that you would have had, even a 30% chance of winning the contract and have 30% of the profit without actually having to do any of the work. So I predict that one future trend is people going to be thinking more about these issues, a greater focus on damages remedies, and perhaps less focus on trying to get the award of contracts suspended. I'll skip over VEET notices and ineffectiveness remedies. Judicial review, page 11. I've discussed at some length the circumstances in which it might be possible to challenge a procurement decision by way of judicial review rather than under the regulations. given the time available, I'm just going to focus for present purposes on two particular points. First of all, can a disappointed contractor seek to challenge by judicial review in those cases that aren't subject to European law at all, i.e. they're not within the regulations and directive for one reason or another, they're below threshold, they're within one of the exceptions, whatever it may be, and also they're not subject to general EU principles because, let's say, they're not of cross-border interest, which is the prerequisite for that. Is there still a judicial review remedy? And generally speaking, the answer to that, well, the answer is, well, kind of, maybe, sort of, all depends on the facts of the particular case. But the general thrust of the authorities is that the courts have usually said, no, these are essentially commercial decisions. And just because they're taken by public authorities does not mean that they are governed by public law. And if they're not governed by public law, then you can't complain about the way they're taken through judicial review proceedings. And a case which, appropriately enough to mention in this location, which sums it all up, is the case of Menai Collect Limited, which I mention on page 12 of the paper, which was about bailiffs' services in Wales. But there are some exceptions to that. For instance, if you're a local authority, and I should have checked this, and I'm pretty sure this is true of Welsh authorities as well as English, there are particular provisions that govern procurement of what are called works contracts, but actually that's a much wider concept than works contracts in the regulation sense. It's most local authority contracts in the Local Government Act 1988, and it has been held that those provisions give sufficient statutory underpinning for there to be a generally available judicial review remedy in relation to such contracts. So local authorities may be susceptible to judicial review even where public authority bodies generally are not. They're also, I think, as any of you from a local authority background will know, currently very much in vogue is the question of the public sector equality duty and judicial review challenges where authorities have not had due regard to equalities issues under the Equality Act. And that's something that is of potential relevance in procurement cases. What kind of contract are we going to procure? What kind of criteria are we going to apply? And that is a complaint which undoubtedly would fall to be made in judicial review proceedings. The other aspect I'm just going to touch on is that of third-party challenges. Now, the only people who've got a right of action under the regulations are economic operators. And economic operators basically mean people who wanted to be awarded the contract. What happens if you are someone else who says there's been a breach of the regulations? Local environmental protester, concerned local citizen, whoever it may be. Is the right of action under the regulations an exclusive remedy for the breach? Or can you say, you've breached the regulations, that's a breach of a statutory requirement imposed upon you as a public authority, so it's a breach of public law, so it sounds in judicial review. If I haven't got a claim under the regulations because I'm not an economic operator, then I haven't got an alternative remedy, so I'm entitled to go for judicial review. So you've got to ask two questions. First of all, does a breach of the regulations sound in public law? Is it a public law breach as well? And at the moment, the courts are saying yes to that. A Court of Appeal case called Chandler, which I deal with in some detail in the paper, and more recently a case I did a couple of weeks ago in which Unison, the trade union, challenged a decision by some primary care trusts to outsource without a procurement because they thought they were cooling off lawfully under a framework agreement. In fact, it was the most unlawful use of a framework agreement I've ever seen in my life. But the second question is, if it does sound in public law, does the third party have standing, which you always have to have in judicial review proceedings, a sufficient interest to complain about it? Now, what the Court of Appeal said in Chandler was the claimant there didn't have standing. She was a parent in Camden who didn't like the idea of an academy school being set up and tried to say the Secretary of State ought to have run a procurement before entering into a sponsorship agreement with the academy sponsor. Court of Appeal said that's no good. You've got to have an interest in the conduct of the procurement, and this is just a wrecking operation. You're not interested in a proper competition. You just don't want a school, an academy here at all. In the Unison case, we thought we had a rather better case on standing. We said a number of things, including that our members, who employs our members, will be determined by who gets this contract. What more direct interest can you have in the identity of the contracting party? We also said that under the relevant NHS procedures, if they ran a proper procurement, we would be given an opportunity to feed in and have our say about the criteria and so on and so forth. Sadly, from my client's perspective, Mr. Justice Eadie has just refused us permission, said we didn't have sufficient standing. He also said we delayed unduly. And he essentially, well, I've set it out in more detail in the paper, but the thrust of his judgment and the general attitude seems to be, well, judicial review is only for people who are almost like economic operators, but not quite. Subcontractors who wouldn't come within the definition of economic operator, maybe representative bodies. The Law Society has been allowed to bring judicial review proceedings about LSC contracts, this sort of thing. We're going to go to the Court of Appeal on it, or may do. We've put in an application for permission to appeal, so watch this space. But at the moment, it looks as if the attitude to third-party challenges is quite narrow and restrictive. Implied contract I'm going to leave out and leave you to read, because otherwise I will be trespassing unfairly on Andrew's time. Complaints to the Commission, though. This is something not to be forgotten, and it is important for three reasons that I've identified on page 23 of the paper. First of all, anyone who likes can complain to the Commission, and the Commission, if it thinks there's something of interest and worth investigating, doesn't care where the complaint comes from. And this has been exploited by, for example, environmental objectors to waste contracts, things like Andrew and I have been doing together in a certain part of the country, where you have to change the nature of the project a bit in relation to planning problems, and then the people who don't want a waste plant at all pop up to the Commission and say that what they're actually doing isn't something they've procured properly. So that's the first thing. The second thing is, a lot of authorities think, 30 days go by, or at any rate 6 months goes by, the ineffectiveness time limit, we're out of the woods, it's all clear. But there is no time limit for the Commission to investigate and, if necessary, bring infraction proceedings. So you're never safe until the contracts actually come to an end. And the third point is that whilst under the regulations, once you've got a concluded contract, apart from declaration of ineffectiveness cases, the only remedy is damages. But that's not true of infraction proceedings. If it goes to the Court of Justice, and the Court of Justice said this contract was improperly concluded, the expectation is then that the member state, the United Kingdom, will bring that contract to an end by hook or by crook. And if it doesn't, it can go back to the court, and a daily fine may be imposed until it is brought to an end of such a size as would make your eyes water. Now, you may think, as an authority perhaps, it doesn't matter if it's an eye-watering fine, because it's Mr Osborne's eyes who are going to be watering and not mine, because the infraction proceedings are brought against member states. But beware, because under the Localism Act, recently enacted, and the relevant provisions, I think, not yet in force, there is provision for a fine imposed on the United Kingdom potentially to be passed on to the defaulting authority that has caused the problem. And the practical issue, therefore, to think about from an authority's perspective is whether, in the kind of long-term project where this could cause problems and where there's a realistic prospect that something might go by way of complaint to the Commission, possibly successfully, do you need to build into the contract provisions that will allow you to disentangle yourself without unduly unacceptable consequences if that happens, so you're not stuck between the rock and the hard place of being fined by the court, passed on by the government on the one hand, or having to terminate in breach and compensate the contractor on the other. I've probably gone slightly over my time, and that is a quick cook's tour through remedies, but we'll pick up at the end any questions there may be. Thank you.
Thank you very much.